You must know your rights and timely assert them. That is your burden. If you do not, then a legal term called laches incurs is in full force. Laches is a species of action wherein a party of reasonable intelligence and integrity, having a right to take an action as is prescribed by law and having failed to timely do so, loses all right to proceed. And it comes like this. If I violate your rights, you may or may not know about it. If you know about it, you may or may not be able to do something about it. If you do have an ability to do something about it, you may or may not have the financial wherewithal to go to a finished program. If you do have the financial wherewithal, you may not have the intestinal fortitude to go to a finished program. So most of the time, your governments and your abusive personalities in government or your corporations pretty much have carte blanche to injure you. Because in 99.9% of the cases, most people will not proceed. But every now and then, you run into that one hard nut. Now, it's important that you understand that this Constitution is in writing. It's important that you understand that it is a legal document, okay? That it was ratified by all of the members in a Congress, okay? And it's important that you understand that there was an offer. Government offered to govern. There was a consideration. The citizens considered how they were going to be governed. And government promised that they would govern by Constitution. And there was an agreement. The citizens agreed that if government promised there would be a government by Constitution, that they would agree to allow the Constitution into force. Now there's a unique situation here. It's very rare when you find the party of the first part, which is the congressmen, officers of the government, who are also parties of the second part, as representatives of we the people, the Republic. And when they signed the document as officers of government, agreeing to the Constitution, and simultaneously as officers of representatives of the people in the Republican form of government. And when they signed that document, that constituted an ironclad contract in writing, enforceable in a court of law, pursuant to the statute of frauds. Now, all we're asking is that they enforce the contract. We want them to enforce the contract. In other words, if we read something in here, and we got a good reason for why we believe it's the way it is, then they should honor that. And they should honor it in favor of you, the clearly intended and expressly designated beneficiary. But I'll get into that a little later. Is Article 6, Paragraph 2 of the Constitution. This is called the Supremacy Clause of the Constitution. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and the treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary or notwithstanding. And when they say notwithstanding, that means notwithstanding in law. Marbury versus Madison, 5 U.S. 137. It's recorded at Volume 5. The opinion of the court was given by the Honorable Judge John Marshall, Chief Justice of the Supreme Court. His opinion was, anything that is in conflict is null and void of law. Clearly, he said that for a secondary law to come in conflict with the supreme law was illogical. For certainly the supreme law would prevail over all other law, and certainly our forefathers had intended that the supreme law would be the basis of all law. And for any law to come in conflict would be null and void of law. It would bear no power to enforce. It would bear no obligation to obey. It would purport to settle as if it never existed, for unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a mere nullity or a fiction of law, which means it doesn't exist in law. But the Second Amendment is one of the most vital amendments here because our forefathers had such an important understanding of life, liberty, and pursuit of happiness, that was the First Amendment, that they turned around and realized that without the right to protect that first right, they didn't have that right. So the Second Amendment, they instituted the right of the people to keep and carry arms, and that right shall not be infringed. Now, they started out by saying a well-regulated militia being necessary for the maintenance of a free state. Okay? Isn't that a true statement, folks? A well-regulated militia is necessary for the security of a free state. That's just a true statement. So is oranges are orange. That's why they call them oranges. Okay? But that doesn't have any legal precedence in theory. The most important part about that Second Amendment is it says the right of the people. And the Supreme Court has ruled in hundreds of cases that whenever it says the right of the people, it means the right each of every single citizen to possess the right equally. Now, a lot of guys like to hand out this manola that, well, that's a collective right. You got to be a member of the militia. That's all hoodoo. You don't have to be a member of the militia. All you have to do is be an American. You have the right. The right to keep and carry arms, and that right shall not be infringed. Now, you will note after infringe, there is no subparagraph A, B, C, D, E, F, G, which would stipulate as to what would be an acceptable infringement. So all infringement is forbidden. Now, who says so? You say so. Do you see that? Does everybody see that? You say so. Who are you? I'm an American. Now, the First Amendment basically talks about the right of life, liberty, and pursuit of happiness, right? But isn't the right to work part of right of life, liberty, and pursuit of happiness? You got a right to work, right? Contract your labor, your skill, and your time of life as you see fit, right? Does that make sense to you? That's a First Amendment right. Another First Amendment right would be the right to travel freely unencumbered. See, no state can require you to have a license to travel freely unencumbered. The second way we can do it is if necessary and proper, our militias can come together and decide to tell these people that are giving aid and comfort to the enemies of our country by breaking down our laws that you have broken the law of Title 18, United States Code, Section 2381, which says that in the presence of two witnesses to the same overt act or in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason, and upon conviction you will be taken by the posse to the nearest and busiest intersection and at high noon hung by the neck until dead. The body to remain in state until dusk as an example to anyone who would take their oath of office lightly. You see, without that oath of office, this Constitution is worthless. That's why we have you take that oath of office, so that we know you will honor this oath of office and that you will keep our Constitution. We don't want anybody taking our Constitution away, and we're here to tell you right now, don't do it. The most important parts about your Constitution are in your first 10 amendments, okay? Obviously, the right of the people to keep and carry arms shall not be infringed, and that right shall not be infringed. You must claim your right if you want to have it. You have to be willing to do that. And if they are going to take your right, then you have to be willing to challenge them, whatever it costs. Now, the bottom line is any law that comes in conflict with that, what do we talk about in Article 6, Paragraph 2? If any law shall come in conflict with this, the supreme law, what happens? It's null and void of law. It bears no power to enforce, no obligation to obey, purports to settle as if it never existed. Unconstitutionality dates from the enactment of such a law, not from any date so branded in open court of law. If any portion of the bill be unconstitutional, the whole bill is unconstitutional. Because why? Repugnancy. Okay? It's repugnant to the United States Constitution. It's null and void of law. It bears no power to enforce, no obligation to obey, purports to settle as it never existed. Which case said so? Marbury versus Madison, 5 U.S. 137, 1803. Other cases that are involved are your rights to due process, like under your 4th and 5th and 6th Amendments, right? The right of the people to be secure in their houses. The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. And obviously that would imply he'd gone before a judge and said, this is the guy, he did it, this is the crime that was done, and this is the evidence we're looking for, Judge, and we'd like to get a warrant, and we're swearing out everything we told you is the God's truth, and then they can come over and they can search till hell freezes over. What does the 9th Amendment say? Enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, basically what that means in simplest of terms, Congress has no authority to add on to the Constitution in such a way that would take away rights previously guaranteed. I don't care how noble the issue it was. I don't care how learned the people claim to be, they weren't learned enough. Because if they were learned, they would have understood the 9th Amendment forbids adding on to the Constitution by any laws whatsoever that takes away rights that are previously guaranteed. Let's hit the 10th Amendment. The powers not delegated to the United States. What are they talking about here? The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. See, this is a limited contract. This contract is designed to limit government. powers. Almost you'll hear this all the time. Well, we have police powers. Broad and sweeping police powers. You look up Black's Law Dictionary of police powers. It says the law of eminent domain of a state or political subdivision to enact laws for the common good and welfare and to curb crime. And in great big black letters it says within constitutional limitations. See the 10th Amendment. Well, when they're talking about see the 10th Amendment, this is the 10th Amendment they're talking about. Now, do they have powers to take away previous rights guaranteed under the Constitution? The answer is obviously no, they don't. Obviously, the 9th Amendment sets a clear limit on that. What is it that they don't understand about the locks on the Constitution? Now, do you see how wise our forefathers were? They knew history, and they knew that history repeats itself if people forget. So what they did is they set a standard, very importantly, toward the end of the contract that clearly stipulated exactly what limits would be there, you see. And it clearly stipulated that no power has existed to take away rights that were previously guaranteed. Now, why are they getting away with it? Because most of the people don't know any better. And if you don't know your rights and you don't timely assert them, laches and curs, laches being a species of action wherein a party of reasonable intelligence and integrity having a right to take an action as is prescribed by law, and having failed to timely do so, loses all right to proceed. So, by you acquiescing, by not jumping up and saying, hey, hold the line, Chester. You ain't touching that 4th Amendment. You aren't touching that 2nd Amendment. We're not putting up with that stuff. You took an oath of office, we're going to hold you to it. You violate that oath of office, we're going to charge you with capital felony treason under Title 18 United States Code, Section 2381. What difference does it make if they're in open rebellion against the United States or if they're breaking down the laws creating the rebellion? Isn't that giving aid and comfort to the enemies of our country? It most certainly is. And it's called sedition. Treason by sedition. Okay? Now we got to start collaring these guys and telling them, hey, what is it you don't understand about the Constitution and your oath of office? We're going to clearly correct that in the short interim. And if you don't want to fix it, we will remove you. And that's our duty and our responsibility. Let's pull up your 5th Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war, or public danger. Nor shall any person be subject to the same offense be twice put in jeopardy. That's the double jeopardy statute. Of life or limb. Nor shall be compelled in any criminal case to be a witness against himself. That's a self-incrimination defense. Nor be deprived of life, liberty, or property without due process of law. That's your equal protection clause. You have an equal right to all of your rights under the law, and you have a right to due process of law. Matter of fact, if they don't give you due process of law, Title 5 United States Code, Section 556D, is clear and specific, and it says if they deny you due process of the law, all jurisdiction ceases automatically. That's Title 5 United States Code, Section 556D, also 557 and Section 706 of that code. In other words, if they deny you due process at any time and you can prove it, you can force a showdown, and you can turn around and say, well, they might have had jurisdiction at one time, Judge, but they lost it when they denied me due process. All right? Now, the other parts are you cannot deny him life, liberty, property without due process of law, nor shall private property be taken for public use without just compensation. You know, how many times do you hear about that today? I mean, it's incredible. The 6th Amendment is another important one. All of them are important, but there are more important ones, all right? In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the action and accusation, to be confronted with the witnesses against him. That's the right to confront your accusers. To have compulsory process for obtaining witnesses in your favor. That's the subpoena rights. And to have the assistance of counsel for your defense, or you can stand as your own counsel. All right, the 7th Amendment. In suits of the common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. It's supposed to say shall remain. And no fact tried by a jury shall be otherwise re-examined in any court of the United States, because the jury is the ultimate trier of fact. Then according to the rules of the common law. But basically what we're talking about here is this comes from the books that tell the judge how, right here and over here, this comes and tells the judge how the Constitution is to be interpreted. This is from the Am Jurisprudence volumes, and this is volume 16. You want the Constitutional Law section, right here, Constitutional Law, and you want section 97. And when you start reading it, the most important part about it, and I'll read it, is that a Constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. Can you see that? Can you all see that? Is that coming out right here? Over more. Okay. All right. To safeguard the liberty and security of the citizen in regard to both person and property. See Note 31, Briars v. United States, 273 U.S. 28, and all of these 40 Supreme Court cases hold that axiom. In other words, it's supposed to be liberally enforced in favor of the citizen for the protection of rights and property. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. 32. Go down 32, DeJammer v. Hospital Authority of Albany, in all of these cases. Let's do that over again. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. Similarly, a provision intended to afford a remedy to those who have just claims should receive a beneficial construction for the purpose of extending the remedy to all who might fairly come within the meaning of the terms. And that's Ryder v. Fitchie of Ohio, a Supreme Court case, okay? This Constitution is a contract in writing enforceable in the court of law pursuant to the statute of frauds. I'm asking for specific performance, Your Honor, in favor of me. I am the beneficiary of the contract. There's also a basic premise in contract law, Basic Contract Law 101 of any first-year law student, that says the contract shall be enforced most favorably in favor of the non-preparer. And that's you. You didn't prepare it. Argument 98. Does everybody see that there? Get it there? Pretty good? All right. Argument 98. While an emergency cannot create power and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions, public emergencies such as economic depression, all right? I'll go over here to the next page. What happened here? All right, let's go. For especially liberal construction of constitutional powers, and it has been declared that because of national exigency, it is the policy of the courts in times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution, right? In other words, they can't be in conflict with the Constitution, to vest extraordinary powers in the chief executive. But I'm telling you, on the other hand, a contention that a grave emergency, such as the Depression, should permit construction of the constitutional provisions which would meet the emergency was rejected. In one case, the court holding that neither the legislature nor any executive or judicial officer may disregard the provisions of the Constitution in cases of an emergency, where the plain and unequivocal terms of the Constitution present to question of construction as to departures in emergencies. So not even an emergency justifies the taking away of constitutional provisions. And I know you've heard differently. I know you think, well, they got an emergency. They just declare an emergency and then the President issues an executive order. But let me ask you, if it's repugnant to the Constitution of the United States, is it law? No. Who says so? We do. We're the people. It's our country. It's our Constitution. We're the ones that say you can't do that. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed with reference to the common law. That means the law of the little people out there, not the corporations. Okay? Since in most respects the federal and state constitutions did not repudiate but cherished the established common law, this fact has been taken into consideration by the courts in construing certain clauses in a state constitution, such as the provisions securing the right to a jury trial. Also, provisions in regard to crimes have been interpreted with reference to the common law rule that one that one charged with a crime may be convicted of a lesser offense necessarily included in the crime charged. In such cases, the courts of the state always regard the language in the common law sense. So the common law prevails. Don't let anybody tell you this admiralty law prevails, because it only prevails if you get sucked into it. We're not going to let you do that. We're going to teach you how to beat it. The common law also permitted destruction of the abatement of nuisances by summary proceedings. Traffic tickets, folks. That's what a traffic ticket does. It is a writ of assistance, a bill of attainder. It's unlawful in the United States of America. And it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense, who said so? Erie Railroad versus Tompkins. Okay? All right? Of a national customary law as distinguished from the common law of England, adopted in the several states. In interpreting the federal Constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to this common law, the language of the federal Constitution could not be understood. So the common law applies, folks. We are now in 16th Am Jurisprudence, Section 117. And I will read it to you. Basically, various facts and circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. They're infringing. Who says so? You do. How shall a document be enforced in favor of who? You. When are you going to enforce it? You're the one that is the citizen. All power is inherent in the people. You're the one with the power. Enforce your power. You see, once you understand this is an ironclad contract, once you understand that this is enforceable in the court of law pursuant to the statute of frauds, once you understand you have a right to claim specific performance on the contract. Your Honor, I'm demanding my right to keep and carry arms, and that right shall not be infringed. I want specific performance. I am the holder of the contract. It's supposed to be enforced in favor of me. I am the clearly intended and expressly designated beneficiary, the citizen. I want the thing protected in favor of my right. Does that make logical sense to you? I want to get into Section 155. 16th Am Jurisprudence, Section 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, got me? Sworn? As an oath of office, sworn? The courts are not at liberty to overlook or disregard its commands or countenance evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus it is said that the courts should be and are alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the deliberate judgment of the tribunal before which the validity of the enactment is directly drawn into question. If the Constitution prescribes one rule and the statute another, and a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. Does everybody understand that? They're telling the judge, you got to rule in favor of the Constitution. And I'm asking the judge to do his duty under his sworn oath of office and uphold the United States Constitution as he swore he would under Article 11, Paragraph 1 in this state, which says that he shall swear to protect and defend the Constitution from all enemies, foreign and domestic, and he will perform his duties to the best of his ability, so help him God. 16th Am Jurisprudence, Section 177. Declaratory judgments. Declaratory judgment actions have often been utilized to test the constitutionality of a statute and government practices. The Uniform Declaratory Judgments Act makes specific provisions of the determination of construction or validity of statutes and municipal ordinance by declaratory judgment, and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statutes and of ordinances. The Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been invoked frequently as a means of assaying the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. You can't enjoin a constitutional right. A court may grant declaratory relief unless there is a case of controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the adjudication. All right? Now, I'm trying to tell you folks here, you have a right to demand a declaratory judgment, which we are going to do in several of our cases here. And they got to declare. Is it constitutional or isn't it constitutional? If it's constitutional, it has to be judged in favor of who? You, the citizen. Why? Because you're the beneficiary. It's supposed to be enforced in favor of you, the beneficiary, the citizen, for the protection of rights and property. See Breyers v. United States, 273 U.S. 28. And the 40 Supreme Court cases that support that mandate. Okay, we're at Section 255. 16th Am Jurisprudence, Section 255. In all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. The Brady Bill. Irreconcilable. Huh? In other words, the court is without authority to declare a statute unconstitutional unless it is in positive or direct conflict with the statute or with the Constitution. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. Because that would be violating the Constitution. We can't have that. What happened in Marbury v. Madison, 5 U.S. 137, same thing. A clear incompatibility between law and the Constitution must exist before the judiciary is justified in holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as to constitutionality should be resolved in favor of the constitutionality and the beneficiary, you, the citizen, for the protection of your rights and property. 256, right here. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it. Here's 35, all right, here's 34. State ex rel versus Nguyen v. Greer. But I'll tell you what, Marbury versus Madison comes higher than that, okay? All right, 34. Let's cover that again. And ineffective for any purpose. Since the unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it, an unconstitutional law in legal contemplation is as inoperative as if it never had been passed. Such a statute leaves the question that it purports to settle just as it would be had the statute not ever been enacted. All right? No repeal of an enactment is necessary. Since an unconstitutional law is void, the general principles follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract, did everybody pick up on that keyword, contract? A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. And where a well, what did I say there? Remains in full force and effect. Is the Second Amendment in full force and effect? You better believe it. Okay? Now what is it they don't understand about infringed? And where a statute which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. In other words, the law stands always. The real law, the Constitution. The general principles stated above apply to the constitutions as well as to the laws of several states insofar as they are repugnant to the Constitution and the laws of the United States. And let's see if 54 will confer. Kuhn versus Berry, but I can tell you Marbury versus Madison is higher than that, but I'd be willing to bet you they cited Marbury in that. Moreover, a constitution of a statute, a construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had, in its expressed terms, been enacted in conflict therewith. So, anything passed in conflict with the United States Constitution is clearly unconstitutional. It doesn't take a college professor graduating magna cum laude from Harvard to figure these things out. All you have to do is read. That's why God gave you eyes now. The actual existence. Well, let's go to 257. 257, same book, 16th Am Jurisprudence. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested, of status, of prior determinations deemed to have finality and acted upon accordingly, of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature both of the statute and of its previous application, demand examination. All right? It has been said that an all-inclusive statement of the principle of absolute retroactive invalidity cannot be justified. Obviously, it would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding upon the people. All right? So you have to pay attention to what's going on. Now, let's get a few more and we're out of here. Section 258. I'm just going to read the important section here. On the other hand, it is clear that Congress cannot by authorization or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. It is stored. Go on over there, grab the 16th volume, start at section 1, and just start paging through to section 300. I'm telling you, you won't believe it. We're going to look at section 260. Although it is manifest that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there are no degrees of constitutionality. In other words, it's either constitutional or it's unconstitutional. There's nothing like, it's kind of like half pregnant. There's no such thing, all right? So that an act is either constitutional or it is unconstitutional. I love it when these guys tell me I don't have any rights. I said, well, if you believe that, let's go to court. And on the end of the day, we'll see who owns who. But I'm going to tell you right now, if you violate any of my constitutional rights, I will sue your socks off and I will attach everything you own, bank, business, and home. And I'm telling you, I'm the one your mama warned you about, so you damn well better listen. Do not violate my rights, because I will come after you, and I will take care of business, and I will do what is necessary and proper, and I will pull every stop out, and I will go dig up every nut, bolt, and screw, and when it's done, you will find out you messed with the wrong American, because this American is not going to back down. Obviously, we have established clearly that you have a constitutional right. And obviously we have established that you are the beneficiary of the contract. And we have established that the Constitution is a contract in writing enforceable in the court of law. And we have established that you have a right to claim specific performance on the contract. And we have established that it's supposed to be interpreted in your favor. So if you've got an honest constitutional belief, they have to listen. Now let's take that to the next step. The next step is, can a state arbitrarily and erroneously convert your right into a privilege and issue a license and a fee for it? Murdoch versus Pennsylvania, U.S. Supreme Court. Murdoch versus Pennsylvania is a unique case. It's recorded at 319 U.S. 105. That's the 319th volume of United States Supreme Court Reports on page 105. Basically, it is a religious test case wherein Jehovah's Witnesses in the year of 1943 wanted their right to be able to go and preach among the public, because that is their right to evangelize, okay? In Pennsylvania, they wanted them to have a license to solicit, okay? This is basically the crux of the case. Now, what happened was the Jehovah's Witnesses claimed their First Amendment right of life, liberty, and pursuit of happiness, the right to worship and exercise their religion unencumbered, right? And, of course, that's one of the mainstays that founded this country, was the religious freedom, okay? And basically the points on the case that are established are: a state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of press and religion and inevitably tends to suppress their existence. All right, I'll start again. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of the press and religion and inevitably tends to suppress the exercise thereof. That the ordinance is non-discriminatory and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. All right? No state may convert a secured liberty into a privilege and issue a license and a fee for it. I want you to understand, we're not talking about whether you're a Jehovah's Witness here. What we're talking about here is, are you an American and do you have rights? What they are talking about here is that these Jehovah's Witness people exercised their rights timely, that they had a right to worship and exercise and worship their God and evangelize as they chose, and that the state came in and arbitrarily converted that right into a privilege and issued a license and a fee for it. That is totally unconstitutional. Now, we took that case as a pioneering case, and we argued that case for all of your constitutional rights. All you need to do is keep in mind that you are an American and you have constitutional rights, number one. Number two, you have to keep in mind what right. Can you pull the right out of the Constitution? If you can pull the right out of the Constitution, and I'll give you an example. How about the right to travel freely and unencumbered, pursuant to Shapiro versus Thompson, and we'll get into that. How about the right to keep and bear arms, right? Does a state have a right to require a license and a fee for the exercise of the right? And if they do, can you ignore the license and the fee? We'll get into that. Now, obviously, in this case, it's clearly established, and this is the premise of this case: no state may convert a secured liberty into a privilege, issue a license and a fee for it, and require you to have that. Otherwise, you committed a crime. That's totally 100% unconstitutional. I want that to get across real clear. Now let's jump to the next case. By the way, Murdoch is recorded at 319. That's the 319 volume. U.S. Reports, page 105. We'll start the case. Let's go to Shuttlesworth versus Birmingham, Alabama, which is recorded at volume 373. The same U.S. Reports. You go to volume 373, turn to page 262. When we go to Shuttlesworth versus Birmingham, Alabama, this is another unique religious case, okay? In this case, 6 ministers were accused, of inciting to riot and otherwise create a disturbance and disturb the peace, okay? They had a sit-down. This case came down in 1962. And what happened was, they said they needed to have a license to have a public gathering, okay? And what happened was, it went to the Supreme Court, and the Supreme Court says, no, you don't need to have a license for the exercise of a First Amendment right to freely assemble, okay? Right, basically, the gist of the case is The Negro ministers were convicted in Alabama State Court of aiding and abetting in violation of criminal trespass ordinance in Birmingham, Alabama. The only evidence against them was to the effect that they had incited 10 Negro students to engage in a sit-down demonstration at a white lunch counter. Actually, there were 6 ministers, but only 2 got charged, as a protest against the racial segregation. Then they cite other cases. A lot of times you can find other cases in these cases. In Gober versus City of Birmingham, Alabama, this court today holds, on the authority of Peterson versus City of Greenville, that the convictions of those 10 students for criminal trespass were constitutionally invalid. Since those convictions have been set aside, it follows that these petitioners did not incite or aid and abet any crime, and that therefore the convictions of these petitioners must be set aside. Now basically what they were claiming is their constitutional right to freely assemble. The cities was claiming that they had to have a license to put on a demonstration, which they didn't have, and they were charging them with a criminal trespass for not having a valid license to freely assemble and or protest, okay? Now, the gist of this case, I want you to see the significance of this case in view of the case we gave you before that. Murdoch versus Pennsylvania clearly established that no state could convert a secured liberty into a privilege and issue a license and a fee for it. Does everybody got that? Shuttlesworth versus Birmingham, Alabama said that if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and the fee and engage in the right with impunity. That means they can't punish you. They got to let you go. All right? Does everybody see that? It's very important that you understand, first, your Constitution is the supreme law of the land, and that you have that right. And that right shall not be infringed, and it's supposed to be enforced in favor of you, the clearly intended and expressly designated beneficiary. It's very important that you understand that no state may convert that right into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says you can ignore the license and engage in the right with impunity. That means they can't punish you. The next case is very important. That's United States versus Bishop. That's 412, volume 412, United States Reports. This is page 346. United States versus Bishop is a very unique case. Basically what Bishop does is it sets a standard for what constitutes a criminal violation in terms of willful intent. Okay? Willfulness is one of the major elements that is required to be proven. In any criminal element, you have to prove, 1, that you're the party, 2, that you had a method or an opportunity to do the thing, and 3rd, that you did so with a willful intent. Now, when we get to willful intent, willful is defined as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, in the previous 2 cases, you have decided that you have relied on the United States Constitution. And you have relied on decisions of the United States Supreme Court. So, could you have willfully done any deed or crime? Obviously not. So guess what? This case stipulates that you have a perfect defense to the element of willfulness. Alright? Since the burden on the prosecution is to prove that you did willfully and knowingly avoid a known duty or task under the law with a moral certainty, he cannot perform that task, can he? Because it's obviously you have a constitutional immunity to that. The previous case, Shuttlesworth versus Birmingham, Alabama, says they couldn't even punish you. The case before that said you didn't need a license for the exercise of a right. And the case before that said your constitutional right is supreme over any state law. So if they pass the law in violation of your Constitution, the Constitution overwhelms the state law. So the law doesn't even exist in law. Does everybody see that? Now, since the prosecutor does not have a cause of action for which relief can be granted, Your Honor, may it please the Court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, may it please the Court, at this time I would motion most graciously for a dismissal with prejudice for failure to state a cause of action for which relief may be granted by this Honorable Court, and I'd kind of like to collect my costs and fees for having to defend this patently frivolous and spurious complaint, sir. May it please the Court. Obviously, you got a right to work. You got a right to contract your right to work as you see fit, not as some arbitrary and capricious bar association sees fit. Right? Doesn't that make sense to you? You don't want to belong to the union, that's your right. This is a right to work state, right? The bottom line is this. They cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. And since you got a perfect defense to the element of willfulness, they cannot punish you. They have to dismiss. They do not have a cause of action. Now, the word willfully has the same meaning, all right? In controlling the voluntary, intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can't prove willfulness, they can't prove nada. Okay? Has everybody got that? Now, let's go to the next one. Now that you've won and your rights have been violated, the next thing they will claim, well, we acted in good faith, or, well, we acted in good faith. We had good faith reliance that you broke the law. Okay? And that means you can't sue us. That's a lie. You see, since these two cases, Owen versus City of Independence, which is recorded at 100 volume, and you want to look at Supreme Court report, and you want to look up Supreme Court reports, and you want to turn to page 1398. There is also a counterpart case to this Owen case, which is Maine versus Thibodeau. Maine versus Thibodeau is recorded at 100 Supreme Court. That's 100th volume. Supreme Court reports, page 2502. Where plain language of a statute supported by consistent judicial interpretation is strong, it is not necessary to look beyond the words of the statute, right? The right of action created by statute relating to deprivation under color of law, of state law, of a right secured by the Constitution and the laws of the United States encompasses claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Now, whenever this happens, folks, you must understand something. And that goes for both Maine versus Thibodeau and Owen versus City of Independence. And I'll tell you the brief synopsis on both these cases. Owen was a police chief in the town of Independence, Missouri. And he got in a gripe with the city council, and they indiscriminately fired him without just cause. Owen turned around and sued. They claimed that they acted in good faith. The Supreme Court said, "Sir, you are deemed to be officers of the law. You are to advise us to the law. You can hardly claim that you acted in good faith for a willful deprivation of the law, and you certainly can't claim ignorance of the law, because a citizen out here on the street can't claim ignorance of the law, and it makes the law look stupid if an officer of the court or some officer of government doesn't know the law, and then they go ahead and abuse somebody's constitutional right." So in matters of constitutional rights, both these cases uphold one point. And the point they uphold is that whenever they violate your constitutional rights, they do so at their own peril. And it even says that in Title 18 United States Code, Section 241 and 242. It says that upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if death results, life in prison. They're telling you, don't violate somebody's rights. Please, don't do that. Title 42 United States Code, Sections 1983, 1985, and 1986 clearly establish your right to sue anybody that does that. Now, they're going to claim you can't sue them because they have judicial immunity. Well, guess what? These two cases remove judicial immunity. There is no judicial immunity for violating somebody's constitutional rights. Judge, you are deemed to know the law and sworn to uphold it. You can hardly claim that you acted in good faith for willful deprivation of the law, and you certainly can't plead ignorance of the law, for that would make the law look stupid for a knowledgeable judge to claim ignorance of the law when a citizen on the street can't claim ignorance of the law. Therefore, there is no judicial immunity. I want to get that across. I don't know how many attorneys come up to me all the time telling me, well, they're immune because they acted in good faith. They're just not reading their court. They're not reading their court reports, because if they were reading their court reports, they would have known this case has been on the books since 1982. Both these cases came down in 1982. So I want you to pay attention to these cases. When somebody tells you they can violate your rights with impunity, you just kind of smile and say, make my day. Okay? Briers is recorded at 273, volume 273, U.S. Reports, page 28. Okay? Now, Briers versus United States is a unique case. It's a search and seizure case, but basically it sets constitutional standards which we had talked about in the Am jurisprudence sections. Okay? I especially want to pay attention to note number 3 here. Constitutional provisions for the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachment therein. All right? When a federal officer participates officially with a state official in a search, so that in substance and effect it is their joint operation, the legality of the search and the use and evidence of the things seized is to be tested in federal prosecutions, as it would be if the undertaking were exclusively the federal agent. All right? The reality here is what they are setting is the standards must be liberally construed in favor of the citizen. It's the duty of the court to make sure that happens. So now, you have a right to be wrong. You have a right to enter your viable defenses that you honestly think. No state can convert that right into a privilege and issue a license and a fee. If they do, you can ignore the license and the fee. They must prove the burden of proof of willfulness, which they cannot do. If they do violate your rights, you do have a right to sue them in Owens v. City of Independence and Maine v. Thibodeau. They have to give every consideration to you, all right? And that's the way it is. Boyd v. United States is recorded at, it's recorded at 116, volume 116, United States Reports, page 616. So everybody got that? Can you see? Boyd v. United States, 116 U.S., page 616. The court is to protect against encroachment of constitutionality or secured liberty. All right? Now, it is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegations, which is pretended they will prove. And a lot of times that happens in federal cases. They'll claim something, they won't prove it. That's happened to me, believe me. And then the fact that they've claimed it makes it true. All right? And then, of course, you have to prove a negative, which is impossible. All right? Now, the seizure or compulsory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself in violation of the Fifth Amendment, and in a prosecution for a crime, penalty, or forfeiture is equally within the prohibition of the Fifth Amendment. See that? Now, the bottom line here is Boyd protects against encroachment of constitutionally secured liberties. It's arguing the Fifth Amendment here, but it's basically arguing against encroachment, all right? So that's one you want to pay attention to when you're coming, especially to things on search and seizure natures. This is the Miranda v. Arizona decision. It's recorded at 384, volume 384 U.S., that's U.S. Reports, page 436. Miranda v. Arizona. This is the one that says you got a right to remain silent, you got a right to an attorney, you got a right to have your attorney present during questioning. Anything you say can and will be held against you in a court of law. If you can't afford an attorney, one will be appointed for you by the court. Do you wish to make any statement on your behalf, and do you understand the rights that I have spoken to you? As soon as they stop you, talk to you, as soon as they start talking to you, they are required to say that. If they don't say that, they screwed up. If they haul you into jail and they don't tell you this, read it to you, and then they want to make you sign a little statement that you know your rights and you knowingly waive them, please, folks, don't sign that statement. Use your head for something other than a hat rack. Do not sign that statement, ever. You are knowingly waiving your constitutional rights. Don't ever do that. These people will lie, cheat, steal. They will do anything they can to hammer you. Their whole purpose in life is to hammer you. I don't want you to think, oh, what nice guys, so maybe we can just work this out. Why don't we just talk and maybe we can get things worked out? You don't talk to these people, folks, and you're talking to somebody who learned the hard way. You do not talk to these people ever. I don't care if you think you're a nice guy and you want to be courteous. I don't think you think if you're going to work it out. I don't think you think if you're smarter than they are and you can beat them. I'm telling you, you don't talk to them, period. You button that hatch. An old wise legal defense counsel told me one time, he said, the first rule is keep your big mouth shut. I said, okay, what's the second rule? Keep your big mouth shut. He said, what's the third rule? Keep your big mouth shut. I said, after you follow them three rules, the rest is easy. It's when you open your big mouth that you get in trouble. Not that you would do anything wrong anyway, but they'll twist, lie, cheat, and steal and make it into something you didn't do, and before you know it, you won't even recognize what's happened. And I'm telling you, it's happened to me. So I'm telling you as a friend. I'm not telling you as a smart ass or anything else. I'm telling you as a friend. Do not talk to these people. They do not have your best interest at heart. And you may think, well, they're the government, and they're responsible. Let's look at this Miranda decision. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges must be observed. The person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent, and that anything he says will be used against him in a court of law. He must be clearly informed that he has a right to consult with a lawyer, and to have a lawyer with him during interrogation. Do that, please. And that if he is indigent, a lawyer will be appointed to represent him. All right? If the individual indicates prior to and during questioning that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, the questioning must cease until an attorney is present. Where an interrogation is conducted without the presence of an attorney, and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Don't test that theory. But I'm telling you, it works. I did it. Where the individual answers some questions during interrogation or custody interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. The warnings require that the waiver needed are, in the absence of a fully effective equivalent prerequisite to the admission or admissibility of any statement, inculpability or exculpability made by the defendant. The limitations on the interrogation process required for the protection of the individual's constitutional rights should not cause an undue interference with the proper system of law enforcement as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdictions. In each of these cases, the statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege against self-incrimination. Now, this is the big one, folks. This is the one they're talking about. Did you properly Mirandize him? Was he Mirandized? Was she Mirandized? If they don't Mirandize you, they got to throw the case out. Almost always. It's very hard to go forward with the case if their witnesses are excludable from the presentation of the case. That's Miranda versus Arizona. Now there's 4 Miranda cases. This is the leading case. There is a Miranda warning case that actually locks down the steps of the warning, and then there's a Miranda interrogation case, which locks out the standards for in custody jail interrogations. Okay. Now, a word to the wise should be sufficient, and I shouldn't have to ever say nothing about that again. Believe me, I learned a valuable lesson. You cannot assume that everybody is a good guy. There are some bad ones out there, and I found them. Now, the next case we're going to talk about is Norton versus Shelby County, recorded at 118 volume, United States Reports, page 425. Basically, that says an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protections, it creates no office. It is in legal contemplation as an inoperative as though it had never been passed. Okay? And that's what this case holds, all right? Now, I'm telling you, you go read the case. Don't screw around. If the judge asks you questions about the case, you better know about what it says, all right? Because if he thinks you didn't read it, he's going to throw your case out. The court follows the decision of the highest court of the state in construing the Constitution and the laws of the state unless they conflict with or impair the efficacy of some principle of the federal Constitution or of the federal statutes or a rule of the commercial or general law. The decision of the state courts on questions relating to the existence of its subordinate tribunals and the eligibility and election or appointment of their officers and the passage of its laws are conclusive upon federal courts, all right? Now, some of the most important thing is, while acts of de facto incumbent of an office lawfully created by law and existing are often held to be binding from reasons of public policy. That's a very important point. Public policy. You want to watch out for the terms public policy. It's often confused with the state's right of eminent domain of police powers. Police powers and public policy are almost the same thing, except one's done without law because we wants to, and the other is done because they're claiming a police authority to do so. All right? But when they're talking about public policy, the acts of the person assuming to fill and perform the duties of an office, which does not exist, can have no validity whatever in law. Okay? An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Okay? Has everybody got that? Now, this basic first portion of this program is designed clearly to help you. And if you take these basic cases on this one page, you will have gone a long way in getting your constitutional rights back. Okay? Now, we're asking you to pay attention. Learn your Constitution. We're going to go into some heavier stuff through the second portion of it. But we want you to learn your Constitution. This book here is a citizen's rule book. It also has jury instructions in it. It also has a lot of important arguments in it. Some of the important arguments in it go along with what we've been talking about. Right? All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 yes, 137. We already argued that one. Where rights secured by the Constitution are involved, there can be no rule or lawmaking or legislation which would abrogate or abolish them. That's again Miranda versus Arizona. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office. All right, that's Norton versus Shelby County, which we just talked about. The general rule is an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void. All right. 16th Am Jurisprudence, 2nd Section 177, and also 256. Officers of the court have no immunity when violating constitutional right from liability. That's Owen versus City of Independence and Maine versus Thibodeau. No state shall convert secured liberties into privileges and issue licenses and fees for them. Murdoch versus Pennsylvania. If the state does convert liberty or privilege into a privileged citizen, can engage in a right with impunity. That's Shuttlesworth versus Birmingham, Alabama. The court is to protect against any encroachment of constitutionally secured liberties. That's Boyd versus United States. Constitutional rights must be interpreted in favor of the citizen. That's Byers versus United States. We have covered all of these cases thoroughly so that you can see clearly. The jury has a right to judge both the law as well as the fact. John Jay, First Chief Justice, U.S. Supreme Court. The jury has the right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice, 1796. Singer. All right. The jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court. The law itself is on trial quite as much as the cause, which is to be decided. Harlan F. Stone, 12th Chief Justice, U.S. Supreme Court. The pages of history shine on instances of the jury's exercise of its prerogative to disregard instructions of the judge. That's United States versus Doherty, 473 Fed 2nd 113. We want you to have a new reverence for your Constitution. We want you to know that a lot of brave soldiers paid for it with their life. We want you to know that they died miserably, some of them. And we want you to know that this is a serious, very serious thing here. We want you to know that we love you, America. And we want you to know we need your help. We need your help. We need your help to learn your Constitution so you can better and effectively come forward, pick that book up, walk out there and shake that book and say, "Shaking it, boss." We're going to claim a First Amendment right to travel. And we're going to claim also a Fifth Amendment. It's guaranteed under the Fifth Amendment of due process and equal protection under the law. We looked up in our state constitution, we have protected a right to travel. The freedom to travel is a fundamental right that should be unlimited by statutes, rules, or regulations which unreasonably burden or restrict movement. A law which substantially affects or penalizes the exercise of the right to travel may be justified only by a compelling state interest and must be tailored carefully to avoid unnecessary infringement on the right. When we come down here, we start reading some of these arguments. You'll notice these little letters here that say, freedom to travel throughout the United States has long been recognized as a basic right under the federal Constitution. See Note 54. Everybody see this little Note 54 here? Again, we're going to take this Note 54. We're going to come down here. And the very first case that we have is Shapiro versus Thompson. That's volume 394, U.S., page 618. And I just happen to have a copy of the case here. And this is Shapiro versus Thompson. The beginning of the case, talking about the purpose of inhibiting migration by needy persons into a state is constitutionally impermissible. All citizens must be free to travel throughout the United States uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. If a law has no other purpose than to chill assertions of constitutional rights by penalizing those who choose to exercise them, it is patently unconstitutional. The Equal Protection Clause prohibits apportionment of state services according to part tax contributions of its citizens. Any classification which serves to penalize the exercise of a right of interstate travel unless shown to be necessary to promote a compelling government interest is unconstitutional. It says that the right finds no explicit mention in the Constitution. So you have an idea and you say, I have a right to travel freely and unencumbered, right? That a right was so elementary was conceived from the beginning to be necessary concomitant of the stronger union the Constitution created. In any event, freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. We've established that the right is clearly there. In moving from jurisdiction to jurisdiction, they were exercising their constitutional right, and any classification which penalizes the exercise of the right unless shown to be necessary to promote a compelling government interest is unconstitutional. First of all, The Constitution is the supreme law of the land, right? We established that. Who said so? Marbury versus Madison, 5 U.S. 137, 1803. The Constitution of these United States is the supreme law of the land. Any law in conflict is null and void of law. Now, we know that the Constitution is supreme. We know that the right is clearly established in Shapiro versus Thompson. Can a state, arbitrarily and erroneously, convert a secured liberty, in this case the right to travel freely unencumbered, into a privilege and issue a license and a fee for it? Obviously, we have decided that in Murdoch versus Pennsylvania, clearly, no state may convert a secured liberty into a privilege. Now, does everybody see how we plug that in? Just like on your computer, you fill in the blanks, okay? You have the court case. It says no state can convert the liberty into a privilege and issue a license and a fee for it. Well, what right are we talking about? The right to travel freely unencumbered, so you plug that in. So does the state have a right to require you to have a license for the exercise of that right? No. Does everybody see that? Now, what happens if the state requires you to have the license? Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity. That means they can't punish you. Now, what happens if they pull you over? They give you the ticket. Well, you're going to go to court and you're going to fight it. You're going to file a brief. We're going to show you how to do that at a later time. We'll show you exactly what to put down there. But these are the cases you're going to be putting down on your memorandum of law as to why you have a reason to feel that you're right. First, that your constitutional right is superior to any law that they would put down. You have that right, and they can't pass a law that takes away that right. Secondly, if they do, it's unconstitutional. Thirdly, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, you can ignore the license and the fee and engage in the right with impunity. Shuttlesworth versus Birmingham, Alabama. And since you have not willfully done anything evil, you have relied on your Constitution and on the Supreme Court decisions, you have a perfect defense to the charge of willfulness. So you could not have been charged with willfully not going and getting the license. Does everybody see that? You have a perfect defense. United States versus Bishop, 412 U.S. 346. Defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, you didn't do that, did you? Because you have a perfect defense. You relied on previous decisions of the Supreme Court, Shuttlesworth and Murdoch and Marbury. You relied on your constitutional right to travel freely unencumbered, pursuant to Shapiro versus Thompson. So you have a perfect defense. So now where are we at? Your Honor, may it please the Court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I would like to motion to dismiss, and I'd like my costs and fees for having to defend this frivolous case. Now, you have a right to collect your time for going to court, all right? You submit your proposed order. You fill out your own proposed order. That makes the case go faster, and the judges kind of like that, and it intimidates the hell out of the prosecutor when you do your own order. Now, let's say, well, that's how you interpret that, sir. That's right, sir. That is how I interpret it. And 16th Am Jurisprudence, Section 97 says that it shall be interpreted in my favor, because I am the clearly intended and expressly designated beneficiary of the citizens for the protection of rights and property. See Briars versus United States, 273 U.S. 28. That deals with an unlawful search and seizure, but it also deals that it's supposed to be interpreted in favor of you, the clearly intended and expressly designated beneficiary for the protection of your rights and property. So they got to enforce it in favor of you, right? Now, Boyd versus United States comes next. The court is to protect against any encroachment of constitutionally secured liberty. It's their duty. They have no choice. They have to do it. Okay? All right? In Norton versus Shelby County, an unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protections. It creates no office. It is in legal contemplation as inoperative though it had never been passed. Wherefore, Your Honor, I pray before this honorable court for your just and lawful relief. I ask that you dismiss this case with prejudice for failure to state a cause of action for which relief can be granted, and I pray the court for my just relief for having to defend this patently frivolous and spurious case, and my costs are whatever they are. You submit that on your order. I have a proposed order, Your Honor. It's in my brief. Well, what do you want to do? How do you want to plead on your case? Well, I don't intend to plead, sir. I intend to answer in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction, because that's an issue to be brought up in my pleadings and briefs to file with the court. Now, did everybody see we take that line down? We take the line from the Constitution. We take the line from the right. Now, let's think up another right. How about the right to work? Contract your labor and your skill and your time of life as you see fit. Your right to work is protected by the Constitution under the First Amendment. Again, you have a right to work and contract your labor and your skill and your time of life as you see fit. I get hauled into court before the chief judge of this big court here in Oakland County. And he leans over the chair and he says, well, it's been reported to me, son, that you don't have a license to practice law. Is that correct? And I looked up at him and I said, Judge, I'm not practicing. I know what the hell I'm doing. And the whole court broke out laughing. He said, "That's pretty good. That's pretty good. I like somebody with a sense of humor." He said, "But that doesn't change anything, son. You have to have a license to practice law." And I said, "Your Honor, I'm an unenfranchised common law free man. I live at the common law. I am not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these illegal corporate Ponzi schemes. I am just Joe Blow from Kokomo, down on the street. I just live at the common law. And I have a right to work and contract my labor, my skill, and my time of life as I see fit, not as some third-party arbitrary and capricious bar association sees fit." I said, "Your Honor, the state of Michigan arbitrarily and erroneously converted my right to work into a privilege and issued a license and a fee for it. That's unconstitutional, Your Honor. Marbury v. Madison, 5 U.S. 137, 1803. Anything in conflict or repugnancy is null and void of law. Marbury v. Madison. And since the state converted my right into a privilege and issued a license and a fee for it, Murdoch v. Pennsylvania, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth v. Birmingham, Alabama says I may ignore the license and the fee and engage in the right with impunity. That means you can't punish me. And U.S. v. Bishop, 412 U.S. 346, defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. I submit, Your Honor, I couldn't have done an evil task because I was totally following the Constitution and the U.S. Supreme Court. I would submit that prosecution counsel's burden is to prove that I did willfully and knowingly avoid a known duty or task under the law, namely to get the license. And I would submit he specifically precluded he cannot perform his task, and therefore I'd motion for dismissal with prejudice failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous, spurious complaint. Quo warranto. Let's read it. Quo warranto. In Old English practice, a writ in a nature of a writ of right for the king against him who claimed or usurped any office, franchise, or liberty, to inquire by what authority he supported his claim in order to determine the right. It lay also in the case of a non-user or long neglect of a franchise is corporation, or misuser or abuser of a franchise, being a writ commanding the defendant to show by what warrant he exercises such a corporate franchise, having never had any grant of it, or having forfeited it by neglect or abuse. A common law writ designed to test whether a person exercising power is legally entitled to do so. An extraordinary proceeding, prerogative in nature, addressed to preventing a continued exercise of authority unlawfully asserted. Johnson v. Manhattan Railroad Company, New York, recorded at volume 289, United States, page 479. Now, it is intended to prevent exercise of powers that are not conferred by law, and is not ordinarily available to regulate the manner of exercising such power. Police power, an authority conferred by the American constitutional system in the 10th Amendment, U.S. Constitution, upon the individual states and in turn delegated to the local governments, through which they are enabled to establish a special department of police, right? Such laws and regulations as tend to prevent the commission of fraud and or crime and secure generally the comfort, safety, morals, health, and prosperity of its citizens by preserving the public order and preventing a conflict of rights in the common intercourse of the citizens, and ensuring to each an uninterrupted enjoyment of all the privileges conferred upon him or her by the general laws, the Constitution, the power of the state to place restraints on personal freedoms and property rights of persons for the protection of the public safety, health, and morals, or to promotion of the public convenience and general propriety. The police power is subject to limitations of the federal and state constitutions, and everybody catch that, and especially to the requirements of due process. Police power is the exercise of the sovereign right of the government to promote order, safety, security, health, morals, and general welfare within constitutional limitations, right, is an essential attribute. Marshall versus Kansas City, Missouri, recorded at 35 volume, Southwest 2nd, that's another reporter, Southwest 2nd, page 877, all right? Now, police powers are the right of eminent domain of a state or political provision to enact laws for the common good and welfare and to curb crime within constitutional limitations. And the key words in that whole thing are within constitutional limitations. The burdens placed on the national government as a result of states' regulation of their internal affairs, save as Congress may act to remove them, constitute normal incidents of operation within the same territory of a dual system of government. And no immunity of national government from such burden is to be implied from the Constitution. All right? All right, Penn Diaries versus Milk Control Commission, all right? A Pennsylvania case, recorded at Volume 318, U.S. 261. The people of the United States residing within any state are subject to two governments, one state and the other national. But there need be no conflict between the two because the powers which one possesses the other does not. That's United States versus Cruikshank, a very famous Supreme Court case. Within the area of delegated powers, expressed or implied, this amendment does not reduce the powers of the United States. That's U.S. versus Manning. Recorded at 215, Federal Supplement, that's another reporter, page 272. The Federal Union has only those powers expressly conferred on it, and those reasonably implied from powers granted, while each state has all governmental powers except such as the people by the Constitution have conferred on the United States, denied to the state or reserved to the people themselves. Anderson versus Gladden, recorded at Volume 188, Federal Supplement 666. It is when federal legislation attempts to confer power upon the national government that it is not within the express or implied powers given by the Constitution that the legislation becomes vulnerable to this amendment. Okay? Now, what are we talking about here? Brady Bill? Huh? They're not within their powers. They have no 10th Amendment powers to take away the Second Amendment. Does that make sense to everybody? They don't have any powers to go and take away the Second Amendment or any other amendment. The Fourth Amendment, the Fifth Amendment, nothing. And the Ninth Amendment precluded them from adding on to the Constitution in such a way that would take away the powers. So by the Ninth Amendment and the Tenth Amendment, they're totally locked out from doing a lot of the things that they do. But see, you got to know that and be able to timely exercise it. So it's very important to understand your Tenth Amendment powers. Now, when in the course of human events it becomes necessary and proper, a writ of quo warranto, all right? Now, this doesn't look like much, but let me tell you something. What we're talking about doing here, see, most cities, at least in the state of Michigan, are by Public Act 230 Public Acts or Public Act 287 of Public Acts, and then it starts listing the rights and powers. Right to have a police department, right to have a fire department, right to have a city hall, right, and it starts listing all these powers. Now, the antithesis to the argument is that if they're not within the Constitution of the United States and the general laws of the state of Michigan, they don't have any rights and powers. Does that make sense to everybody? In other words, they're in violation of their corporate charter, their franchise. They promised they would be within the Constitution of the United States and the general laws of the state of Michigan. Now, a lot of people, they don't understand the power of this argument, so I want to really push this one home. I want you to understand. Whenever these little townships and these little cities and what have you, they start acting like King Farouk and that you don't matter and that they don't got to listen to you, this is what I want you to do. You ask them a pointed question and ask them, are you violating my constitutionally secured civil rights by however you claim they are? Because if you are, you have just waived your right to be the city of. And they'll laugh at you for a little bit, okay? Then you explain to them Public Act 230 of Public Acts, which states the Rights and Powers section subject to the Constitution of the United States and the general laws of the state of Michigan. You have rights and powers. The antithesis to that argument is if you're not going to be within the Constitution of the United States or the general laws of the state of Michigan and you're going to violate my constitutional rights and trample my rights, what we're going to do here is we're going to go for a writ of mandamus in quo warranto. But it is an ancient law that goes way back to England in the ancient times. And basically here is a judgment and a capious action for it, right? You put down here the case. The case came on regularly for trial before the Honorable, and you put the judge's name in there, whatever it is, on a jury trial or non-jury trial, dated such and such. The name appeared as for your counsel and the name appeared for opposing counsel, right? The court heard the testimony and examined the proofs offered by the parties. The court considered itself fully advised in the premise filed in its findings of fact and conclusions of law, and directed that judgments be entered in accordance with such findings, right? Which means they figured out that they violated your constitutional rights. They didn't have a right to violate your constitutional rights, and in the hearing you showed they violated your constitutional rights, and the judge figured out they violated your constitutional rights. So now, for your prayer for relief, we're going to get this quo warranto. It is therefore ordered and adjudged and decreed. 1. Defendant corporation, the city of, you put down what name, has violated provisions of the act under which it was created, and also has violated provisions of Public Act 230 of Public Act Section 2.2 Rights and Powers Section. In other words, it didn't uphold the Constitution of the United States or the general laws of the state of Michigan. Defendant corporation, the city of, whatever, Pontiac, whatever, accordingly has forfeited its charter and become liable to be dissolved by the abuse of its power. How much money am I talking about here, folks? We'd be in about 9 decimal places plus, wouldn't you, don't you think? Now, do you think they're going to bother some little doctor when they're looking at shutting down a major city? What do you think's going to happen? Everything's going to get quiet and they're going to let the good doctor go. Same thing for you. Now, defendant corporation, you name them, therefore is dissolved, and the corporate rights, privileges, and franchise of defendants are declared forfeited to the people. Defendant corporation, you name them, as trustees, directors, managers, and other officers, attorneys, and agents, are forever restrained and enjoined from exercising any of the corporate franchise powers, rights, and or privileges previously exercised by defendants said city, and from collecting or receiving any debts and or demands belonging to or held by defendant city, whatever, and from paying out or in any manner interfering with, transferring, or delivering to any person any of the deposits, money, securities, property, and effects of the defendant's city or held by it. You name a trustee, which the state would do, probably the Attorney General, after your complaint is filed, is appointed receiver of all of the property, real and personal things in action and effects of defendant city corporation held by and vested in defendants or in or to which defendant may be in any wise interested or entitled thereto. Plaintiff, the people of the state of whatever, that's us, state of Michigan, shall recover of defendant corporation, whatever, city of, the sum of damages, real and personal. Got me? They don't like that when you start talking that, because they can go 100 million 3 times that amount punitive damages. They get a little upset. As costs and disbursements of this action, and the receiver is directed to pay this sum out of their pocket to whoever, the Attorney General, but you can have a person stipulated on there as an injured party. Now, you put down there the Honorable Judge so-and-so presiding, the date entered, and he signs that, and that city is no longer a city. Here is a summons for quo warranto. This is for the start of the thing. Right here. Summons. Form 41. By the way, you can get this in 21 AM Juris Forms and Practice. Your practical forms and practice. Alright? You name the party, you put down there who you are, the people of the state of Michigan versus, you are summoned to appear before which and which court on such and such a date to show by what authority you claim to have, use, and or enjoy the rights and liberties and franchise, namely the corporation city of, set out and complained of in such and such a time, summons, and further to do and receive all things which the court shall then order concerning you. This is kind of like pulling their driver's license for drunk driving. But in the Constitution of the state of Michigan, the latest and greatest, the very first thing they talk about, notice it says Section 1. All political power is inherent in the people. Government is instituted for their equal benefit, security, and protection. Now let me ask you a question. Do you feel equal benefit? Equal protection and discrimination. No person shall be denied the equal protection of the laws. Right? Nor shall any person be denied the enjoyment of the civil or political rights, or be discriminated against in the exercise thereof, because of religion, race, color, or national origin. The legislature shall implement this section by appropriate legislation. This is something you got to understand. Generally, The police power is the exercise of the sovereign right of the government to promote order, safety, and health and morals, and the general welfare of the society within constitutional limits. Within constitutional limits. Did everybody hear that? Within constitutional limits. Generally, the police power is the exercise of the sovereign right of the government to promote order, safety, health, and moral, and general welfare of the society within the constitutional limits. As otherwise stated, the police power of the state is a power or organization of a system of regulations to foster the health, order, and comfort of the people, and to prevent and or punish injuries and offenses to the public. Right? But it has to be within constitutional limitations, and it embraces all rules for the protection of life, liberty, and property. Now, this is something important you got to understand. You're going to be your own attorney, then you got to know all of the programming. When you hear him call your case, you get off your tail feather and you run right up there as quick and expediently as possible without knocking anybody down, and you say, "Ready, Your Honor." You state your appearance. "I'm so-and-so, hearing before this honorable court. I am standing as my own counsel. In my state, it's under Article 1, Section 13. I've appointed myself my own attorney, and I'm ready to proceed with my administrative and procedural matters. And at this time, Your Honor, may it please the court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted." But the judge bips off right away. "Well, you got a ticket on such and such." I said, "Whoa, Your Honor." I said, "Are you the judge, the disinterested third party that's trying this case? The trier of fact?" He said, "Yes." I said, "Okay." I said, "Is this the prosecutor over here, to my right?" He said, "Yeah, that's him." I said, "Okay." I said, "Are you going to prosecute this case, Your Honor?" He said, No, I'm the judge." I says, "And why are you asking discovery questions?" "Well, I just want to find out what's going on." I says, "Isn't that his job over there? That's what he's supposed to do. He's supposed to present his case as the prosecutor, trier of the case. You're the trier of fact, he's the trier of the case." I said, "If you're going to operate as the judge and the prosecutor, I'm going to object on the record as a mistrial." He said, "Okay, I'll let you enter that on the record. Go ahead." I said, "Okay, let it be entered on the record as an appealable issue." He said, "Okay." He said, "Now it's on the record." He said, "Let me ask you this. You get a ticket on September the 30th? I said, "Yes, sir." He said, "Well, let me ask you this. Do you have any plates on your car?" I says, "No, sir. And I don't intend to get any." And now, of course, all the people in the court, "Oh, this guy's going to jail. Watch this. This is going to be good." He says to me, he says, "I assume you have a very good reason for that." And I said, "Yes, sir," and I shut up. I waited. He said, "Can I hear it?" I said, "Well, Your Honor," I said, "I'm an unfranchised common law free man. I'm not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these corporate Ponzi schemes. I'm just a little Joe from Kokomo. I live on the block. I travel at the common law. And I have a right to travel freely and unencumbered pursuant to Shapiro versus Thompson, and that right is so basic it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously converted my right into a privilege and issued a license plate and a fee for it. Murdoch versus Pennsylvania says no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says I can ignore the license and engage in the right with impunity. That means you can't punish me. Since I have relied on previous decisions of the U.S. Supreme Court and on constitutional defenses, I have a perfect defense for willfulness. I am immune to the prosecution. Therefore, prosecution counsel does not have a cause of action for which relief can be granted. I'd motion for dismissal with prejudice for failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous case. He laughed. He says, "Motion granted," and he ran off the bench before I could get my damages. So I went out in the hall. He went to the can. I waited for him. He came out of the can. I served him with my papers. He said, "You didn't have to do that." I said, "Well, I didn't want you to be inconvenienced, Judge."
I'm saying like they want to base their argument on a constitutional right, and I've heard of judges speaking up and saying, "Well, the Constitution has no place in my courtroom." How can they even think about that?
Boy, that is a very serious statement. Because what that judge just did in an open court of law under Title 18 United States Code Section 2381 is he just committed an act of treason. See, the judge is sworn under Article 11 in this state, Paragraph 1, that he will uphold the Constitution of the United States and move as most immediately as is practicable to defend that Constitution, and a violation of that act would be capital felony treason under the people and government of the United States of America, and he would be subject, upon conviction, to be hung by the neck. That's how serious.
If the defendant had a driver's license and they were trying to argue a traffic matter and they were kind of in the system already, And raise
Right.
the constitutional objection that the judge might say
Right.
it doesn't apply.
Well, here's how we start a lot of these traffic cases, and I'll get right into that. The issue, when you first walk before a traffic court, you see, when they merged these courts together in 1963, they screwed up. They wanted to lay off half the judges, see, and they only wanted to have one building. So what they did is they merged the traffic court per se, or that docket, into the criminal court docket. And when they did that, they didn't check the rules, you see. And when they didn't check the rules, they didn't allow for jurisdictional challenges between the two courts. So what happens now is you come before the court, and there's several ways you can come before the court. Now, this gentleman here is correct. When he's talking about you have a driver's license, you have entered into a contractual relationship with the state. In other words, it's not a lawful contract because you cannot enter into an unlawful contract. You understand? It is a contract, though, because it's recognized as a contract. Because you have voluntarily entered into this contract, you agreed to all of the rules in their law book for that contract. Now, this is what we call admiralty and maritime jurisdiction, or artificial jurisdiction. And it's a rather heavy argument going into Erie Railroad versus Tompkins and McCulloch versus Maryland, and we'll go into that in depth at the end of this program, but I wanted to share with you briefly. When you sign your driver's license, and especially today, and your voter's registration card, you will notice a little note right under your signature where you agree to the acceptance of the duality of citizenship of not only at the common law, but you accept the national jurisdiction under admiralty and maritime jurisdiction, which allows you to be sucked into all of these uniform commercial code requirements. And this is a very serious thing you're signing here. You don't understand it, but you just sold all your constitutional rights down the sewer when you signed that document. So when you sign it, my honest advice, and this is from experience, you sign the thing, and right at the end of your name, you write UD. U period D period at the end of your name, and underneath your name you write 1-207 without prejudice. Now what that does, it says, I'll be glad to accept your ridiculous privilege. I don't really need to, but I will, just to keep myself from being in trouble with the cops. And I'll tell you what we'll do. We'll exercise our Uniform Commercial Code caveat that allows us to keep all of our constitutional rights. In other words, my signature is not really a signature of contract, it's a signature of convenience. But I highly recommend everybody lose their wallet and go down and redo their driver's license and sign the thing UD when you sign it, and put 1-207 without prejudice. Because right then and there you cut off all of this admiralty and maritime jurisdiction and you return back to your contract law of what? You're a common law citizen living at the common law. And they can have their contract, but it's not enforceable. Why is it not enforceable? Because you can state that you signed it under duress. Well, how do I know that? Look, I put UD right after my name. U period D period. What do you think that means? Under development? Under the deck? That means under duress. When I signed this, I was under duress. I didn't voluntarily sign this. I had to sign this or the cops were going to cuff me about the head. You see, I was under threat, intimidation, coercion. I still believe that I have a right to travel freely unencumbered. Notice you're not driving. You have a right to travel. The customary usage of the right to travel today is you get in a car. You don't go down to 7-Eleven on your bicycle, you get in a car. Want to go down and pick up a carton of milk, you get in your car. Another unique argument along these lines is, well, Judge, I asked this judge, I says, let me ask you a question, Judge. If I get in my car, the Constitution was still in effect in full force before I got in my car, right? Oh, yeah. Now, when I got in my car and I had my gun, it was still in effect, right? But when I closed the door, the Constitution was suspended, and everybody broke out laughing. How could that be? The act of getting in the car and closing the door made the Second Amendment unconstitutional. I said, that's totally ludicrous. How could that possibly be? You see, they have passed these laws, and they've gotten away with it for so long that they just, it's kind of like a bank robber that's robbed 25 banks in a row, and on the 26th is a little miff that you getting excited. Man, I've done this 25 times. What's the big deal? Now you're going to bust me on the 26th time and you're going to get all upset. See, they've been getting away with it so long, nobody's ever taken them to the task. They feel like, well, I should be able to get away with it on the 26th time. An unconstitutional act, wrongfully done. It doesn't matter how many times in a row you did it, it's still unconstitutional. And the reality is, a person that's properly motivated, properly trained, and properly willing to do whatever is necessary and proper to defend the Constitution will almost always prevail on the merits. And that's what we're doing right now, and they're sweating on that right now. But the reality of this is, and you got to understand, the burden is on you. You want your Constitution, and you damn well better grab a hold of it, and you better hold on tight, and you don't let go for nothing. You read your Constitution, you learn your Constitution, you quote your Constitution chapter and verse, frontwards, backwards, upside down. When people come up to you, well, we want you to take a drug test as part of your job. Go fish. I ain't taking no drug test. I'm not required to prove a negative. You're required to prove a positive. If you think I'm doing something negligent, fine. Then you go file papers and you take necessary precautions and what have you, and we'll go to court. I says, but I'm not going to be convicted before the fact, and then I got to provide evidence that I'm not guilty. That's the cart before the horse. That's back-asswards. We're not going to do that. Not only that, the Fifth Amendment says I got a right not to be a participant in a compulsory process that's going to make an incriminating situation to me. Now, I'm not nothing to hide, and I'm not even arguing from what I got to hide. I'm arguing from the fact that the right stands, and I'm exercising it. And then I usually ask some simple questions. Well, if they find anything when I get fired, hell yeah. You're going to be penalized. So there are penalties. And if they find anything when I be criminally prosecuted, could be. Huh? So why would you want to do some damn stupid thing like that? And give them a piss test. This guy comes up to me at the last convention we had, and they want to take a test as to whether or not he's got any drugs in his system. I said, first of all, what's in my system is between me and my doctor, and none of your damn business. I said, I don't take drugs, and I got nothing to hide, but I'm not going to voluntarily enter into anything. What if your guy screws up and now you say I got drugs? Now I can't get a job ever? What, are you kidding me? This some new hobby you just took up? I'm not going to play that game. It is not my burden to prove a negative. It is your burden to prove a positive. If you have a just claim for which relief can be granted, you go file your papers and we'll sit down and talk. But until such time, you go fish. Because I'm not going to play. I'm not required to play, and I'm not going to play. And if you fire me for the exercise of my constitutional right, I'm going to tell you about Miller versus United States, which says, the claim and exercise of a constitutional right shall not be converted into a crime. And you're doing that, and you're punishing me. And if you fire me for it, I will sue your socks off and attach everything you own, bank, business, and home. Your Honor, may it please the court, is this a court of law, or is this a court of equity? He will immediately sound off with, there's no equity here, just like he got hit in the knee with a hammer, and his leg jumped. And just that fast. It'll happen that fast. Because he thinks there's no lawsuit here, therefore there's no equity. See, the judges don't even understand what happened with this shift from 1963 where they moved these courts together. So you got to find out what hat the judge is wearing. Is he wearing a criminal hat or is he wearing the civil hat? Your Honor, I am representing myself as my own counsel. I would like to proceed with my administrative and procedural matters, but before we go, I have a declaratory ruling, sir. Could I ask you a question? She goes, oh, sure, honey, go ahead. He says, but you understand, only a fool stands as his own attorney. She says, that may be, sir, but I'm the best person that knows the facts of my case, and I think I have a chance. I'd like to try. Is that okay? No problem. You have a right. Is this a court of law, or is this a court of equity? The judge immediately, there's no equity here. She said, thank you, sir. She rolled up her hand. In the hand was a ticket that said civil infraction right across the top, and she said, how may we hear this civil infraction, sir? The judge did a Homer Simpson. He goes, whoo! But now the next effective step that you can do is you can turn around and ask the judge if he's a licensed attorney to practice law. Because none of the judges are licensed. Take my word for it. Michigan Constitution says under the Adjudicature Act that they are by law to have a license, that they are required to be licensed by the state of Michigan. The state of Michigan does not license attorneys. The Bar Association licenses them. They give them a P number and a card that says, yeah, you're a member of the Bar Association. But if you call up the Bar Association, they will tell you they don't give nobody a license. The state of Michigan doesn't give them a license. The Bar Association didn't give them a license. So what license could they be talking about? A Mickey Mouse license? Because that's the only one that's left. The state doesn't issue one, the bar doesn't issue one, and the one they got hanging on the wall is not a license from the state of Michigan. And the Constitution of the state of Michigan says all judges will be licensed to practice law before the state. And you ask him, where's the guy's license? He doesn't have one. And, Your Honor, may it please the court, if since you don't have a license, I'm asking you to recuse yourself until we can get a judge that has a license. Now, a little lady named Virginia Crofts, she's the one that perfected this argument. She's a genius at it. She's a little spitfire. If you ever watch her in court, you're actually going to see a treat because she is something else. She's got character. She graduated a full attorney from Wayne State University. And then she refused to join the bar because she didn't want to compromise her rights with their political chicanery. And she is a full-fledged, serious business, legal person. And to hear her work in court is absolutely like listening to Stradivari work the violin. She walks in and blows their doors off. Well, she's on about 3 judges now for this same thing. She blew the first judge out, so then they sent in another judge. They moved her over to the other side of town, over in Berkeley, Michigan, and then she walked in and she blew that judge out of the door. So then they sent her to another judge, and then she turned around and went before the state licensing commission, and now they've handed it up to the judicial people of the state to try and resolve the problem. They're going to end up dropping it. The judge doesn't have a license. Now let's suppose the judge could prove he has a license, which he doesn't. Judge, let me ask you a question. Under your retirement fund, isn't it a fact that you get a certain percentage of the rake-off of all of the tickets that come before your bench? Well, yeah. And isn't out of a $40 that comes across your bench, you get $18.75? Well, yeah. So you have a financial interest in this matter, isn't that correct? Well, yeah. Well, isn't that a violation of Judicial Canon number 7? You're not supposed to have any financial interest in any matter that comes before your court. I'm going to ask you to recuse yourself for bias, Your Honor, may it please the court. And every single judge has got it. Now, does everybody understand how many ways you can hammer them just out of the chute without even getting nasty? The judge don't have a license. The judge has got a personal interest in the case for financial reasons. There is no jurisdiction to hear the matter, and I'll tell you a secret. Once you challenge jurisdiction, the burden falls on the plaintiff to prove jurisdiction. See? And he can't do it. It cannot be done. There isn't any. There is no jurisdiction to hear a traffic ticket in the United States of America. I know, you're sitting back, oh, come on, they've been getting this for years. A traffic ticket is a writ of assistance or a bill of attainder. You look in your Constitution, you'll find out bills of attainder are against the Constitution. And it's stated at least twice that I know of, all right? I'm telling you, you read your Constitution. There is no place for a traffic ticket. You cannot have a writ of assistance that has civil equity arguments that transmit into law penalties. They can't throw you in jail for a debt because that's a debtor's prison. We have a constitutional argument against that also. So how do they do it? Because they wants to, and because you don't know any better. That's how they do it. Okay?
What if they have a court of, they say it's a court of equity?
All right, that's a good question. I'm glad you're paying attention here. If they say they have a court of equity and there is equity, then you turn to them and say, thank you, Your Honor, I appreciate your time. I would like to know who is the injured party and where the contract is. Can you show me the contract? There is no contract unless you didn't sign your license on UD 1-207 without prejudice. Where is the contract? It's when you sign for that license. So don't sign for that license unless you put UD 1-207 without prejudice, UCC 1-207. Now, they can't produce the contract, and if they could produce the contract, you've exercised your waiver under the contract not to give up your constitutional rights to travel freely unencumbered, right? And let me ask you this. Can you enter into an unconstitutional contract? Not lawfully. The contract is voidable for not lawful performance. It has to be a lawful contract for you to enter into it. All right, now the next thing. Who's the injured party? Who got injured? Show me, Judge. The parking meter out there? Another neat trick that I like to do, especially in speeding tickets, is I like to confront my accuser. I always like to call a black box that accused me of speeding to the stand, and the judge always gets upset. Now, we got Article 1, Section 10, right here. For those of you who are looking for no bill of attainder or ex post facto law shall be passed. That's traffic tickets, folks. A bill of attainder is a traffic ticket. Can you see that right here? No bill of attainder or ex post facto law shall be passed. Alright, but Article 1, Section 10 is basically no state shall make anything but gold and silver coin a tender in payment of debt. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit. What is a Federal Reserve note? Make anything but gold and silver coin a tender in payment of debts. Why? Because it creates inflation. You got to understand that paper money, if you can't redeem every piece of paper in a society, the amount that you can't redeem is inflation or credit. Credit is inflation, right? Pass any bill of attainder, huh? What is a bill of attainder? Again, a traffic ticket. Ex post facto law, or law impairing the obligation of contracts or grant any title of nobility. When they give these guys these gun permits because they got $3,000 in their pocket and they're a rich businessman, isn't that a title of nobility? Because they get more rights. They're more politically correct than you. They have rights, you see. I mean, they violate so many things it's not funny. Now let's talk about treason here. This is the penal code, and we're talking about treason. Whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years and or fined not less than $10,000, and shall be impeachable of holding any office under the United States. All right? After this section, it gives you all of the reasons of how you can be charged with treason. But the basic issues come under adheres to their enemies, giving them aid and comfort. Now, breaking down the laws of our country has also been construed as giving the enemies aid and comfort. So if they're violating their oath of office and they're not upholding the Constitution, that is treason. Because in so doing, they create anarchy in the land. And in that, they aid the enemies of our country. Does that make legal sense to you? This is Title 22, United States Code, Section 286A. Compensation for services. No person shall be entitled to receive any salary or other compensation from the United States. Did everybody get that? From the United States for services as a governor, executive director, counselor, alternate, or associate. The United States Executive Director of the Fund. What are we talking about here? The International Monetary Fund. Shall not be compensated by the fund at a rate in excess of the rate provided for an individual occupying positions at level 4 of the executive schedule under Section 5315 of Title 5 United States Code. Alright, the United States Alternative Executive Director to the fund. What fund? The International Monetary Fund. Shall not be compensated by the fund at a rate in excess of the rate provided for an individual occupying a position of level 5 of the executive schedule under Section 5316 of Title 5 United States Code. The Secretary of the Treasury shall instruct the United States Executive Director of the Fund to present to the Fund's Executive Board a comprehensive set of proposals consistent with the maintaining high levels of competence of the Fund, personnel, and consistent with the Articles of Agreement, with the objective of assuring that the salaries and or other compensations accorded fund employees who fund, International Monetary Fund, do not exceed those received by persons filling similar levels of responsibility within the national government. Got me? Service or private industry. The Secretary shall report these proposals, right, together with any measures adopted by the Fund's Executive Board to the Congress prior to February 1, 1979. Now, folks, when they're talking about the Fund, they're talking about the International Monetary Fund. And when they're talking about being paid, people like Janet Reno, who is the governor of the Fund, is paid by the IMF. And who are they talking about? The Secretary of Treasury shall instruct who? Now these people are paid by another government to our people. That is a violation of our laws. You understand? I mean, if they catch a congressman on the take, what happens? He's out of there. Why? Because it's considered to be unethical activity. Yet this foreign operating program, this International Monetary Fund, is paying our officers as executive officers. Whose interest do they serve? Do they serve the United States or do they serve the funds? Does that make sense to you? Okay. To me, this is an act of sedition or treason. The bottom line is they are not operating in the best interest of the United States of America. They are operating in their interest. And they are paid by a foreign power. And how can they sit in an office of government in the United States of America paid by a foreign power? It's inconceivable that this is going on. Now, these concurrent resolutions here expressing the sense of the Congress regarding the need for the President to seek the Senators' advice and consent to ratification of the United Nations Convention on the Rights of the Child. Okay. United Nations consent on the rights of the child. Okay. John Conyers is in on this. He's one of our guys, too. Okay? Now, the bottom line is they're setting standards, all right? And on these standards, whereas it is estimated that every night in the United States at least 100,000 children go to sleep homeless. Whereas, I mean, they make all these allegations. Wherein the United States has the world's largest gross national product, yet American children rank below the top 15 nations in regard to the health and well-being. Whereas in 1989, the infant mortality rate for the United States ranked 19th in the world, being Singapore or Spain. I mean, they make all these allegations about the United States, and the National Commission on Children has declared that every child in America needs an excellent education, yet approximately 40% of the nation's children are at risk of school failure. I mean, they go on and on. Whereas the United States, 2,600,000 children were reported to be abused and or neglected in 91. Children tomorrow, I apologize to you on behalf of those in my time for the things we didn't do. We didn't stop the tyrants so your fate could be prevented. We watched them steal our freedom, but our silence we consented. We didn't choose to circumvent the doom you've not escaped, while the Bill of Rights was murdered and the Constitution raped. Some of us were lazy and too busy, others too afraid, to think about our children, the ones we have betrayed. We say we were too busy to be concerned or care, to try to ease the burden of the chains we've made you wear. A debt of 17 trillion, more money than exists, because we failed to heed God's call of usury resists. We could have been good shepherds when the wolf got in the fold, yet watch the flame of freedom die, which leaves you in the cold. We changed our great republic, which was forged in blood for liberty, to a socialist welfare state, which we call democracy. I'm sorry we were so timid, betrayed by a selfish generation. We left yet a remnant of a free and prosperous nation. I'm sorry for our action, like sheep we have behaved. We could have left you freedom, instead you are enslaved. Children of tomorrow, descendants of our land, I'm sorry we allowed this fate, you now must understand. Children of tomorrow, educate yourself if by reading the Bible to break the chains we left you with maintain. God's 10 Commandments, use reason, logic, and common sense. Suffer the little children to come to me, for such is the kingdom of God. Dennis Byron. This come off of the Amateur Radio Freemen's Bulletin Board, August, September 1992. End of transmission. We want to cover about the 1-207. Remember I told you sign your name, 1-207 UCC, 1-207 without prejudice. This is it right here, folks. This is the 1-207 Uniform Commercial Code. Can you get that? Okay. Got it? Alright. This section provides machinery for the continuation of performance along the lines contemplated by the contract. What contract? The bankruptcy contract. Despite, that's in 1933, pending dispute by adopting the mercantile device of going ahead with delivery, acceptance, or payment without prejudice, under the protest, under reserve, with reservation of all our rights, and the like. All of these phrases completely reserve all rights within the meaning of this section. This section, therefore, contemplates that limited as well as general reservations and acceptance by a party may be made, subject to satisfaction of our purchaser, subject to acceptance by our customer, or the like. This section does not add any new requirement of language of reservation where not already required by law, but merely provides a specific measure on which a party can rely as he makes or concurs in any interim adjustment in the course of performance. When they say performance, they're talking about contractual performance. It does not affect or impair the provisions of this act, such as those under which the buyer's remedies for defect survive acceptance without being expressly claimed. If notice of the defect is given within a reasonable time, nor does it disturb the policy of those cases which restrict the effect of a waiver of a defect to reasonable limits under the circumstances, even though no such reservation is expressed. Now, this is all what they're talking about when you write down without prejudice. They're telling you you have a right to reserve your right. So I'm telling you to use it. Don't screw around. Sufficiency of the reservation. Any expression, can you see that? Any expression indicating an intention to preserve rights is sufficient, such as without prejudice, under protest, under reservation, with reservation of all our rights, under duress is another one. The Code states an explicit reservation must be made. Explicit undoubtedly is used in place of express to indicate that the reservation must not only be expressed, but it must also be clear, under duress, that such a reservation was intended in advance, right? The term explicit as used in UCC 1-207 means that which is so clearly stated or distinctly set forth that there is no doubt as to its meaning. Okay? Now that is the reservation I want you to claim. Let's look at the very first book of Title of the United States Codes Annotated. And I don't care which section you grab. Grab either Lawyer's Edition, or if you grab... I want you to take a particular note to this and pay close attention. I want this amplified if you can do it. I want it to read right here. The part where it says, this title has been enacted into positive law. Notice the little asterisk right here, folks? There's a little asterisk right here. Everybody see that? Can you see that? You see my pen? Move it till you see my pen point come in. You see my pen point? All right, all right. This title has been enacted in as positive law. Okay? Notice the little asterisk. When you come down here, and all these titles that got the little asterisk, they're all part of the law. Title 11 bankruptcy, Title 13 census, Title 14 Coast Guard, you know. Copyrights, you got crimes and criminal procedure, Title 18, right? Now, I want you to notice something as we come over to Title 26 here. Title 26 is the Internal Revenue Code. It's never been enacted into law. It's a regulation. Can you get it? Can you get it? See that? Look closely. Title 26 and Title 27. Do you see an asterisk there? You don't see one, do you?
No, sir.
That's because there ain't one. Now, let's look at the other version. The other version is exactly the same. And this is the one out of the official U.S. reports for titles. And this one says, can you get my pen? You tell me when.
All right, there.
Okay. This title has been enacted as law. Look at all the titles that got an asterisk. You'll notice again, Title 26 and Title 27, Zippo. No asterisk. Everybody see that? Real clear? Pull it over. No asterisk. Obviously, it's never been enacted as law. How could it be? I'll tell you how. I got a case over here called Erie Railroad versus Tompkins, and I'm going to bring it to your attention. Erie Railroad versus Tompkins is a magnificent court case. This court case is recorded at Volume 304, United States Reports, Section 604. Now, what this case does is it sets up a duality of citizenship. There are the citizens that live at the common law, and there are the citizens that live at the national law, or what is called Admiralty and Maritime Jurisdiction. Now, the way they get away with putting this Title 26 and this Title 27 out, the way they do it, is they create this Admiralty and Maritime Jurisdiction, and if you volunteer into it, you are in it. If you step in it, it's on you. How are we going to remedy this situation? 1-207. Without prejudice. You sign anything that has to do anything with those guys, take the rights if they'll give them to you. Take the benefits. But make sure when you sign it UD 1-207 without prejudice. And that makes you a common law citizen. And when they pull you into these courts and they claim they have jurisdiction over you, you say, the first thing out of your mouth is, Your Honor, may it please the court, before this matter goes forward, I wish to state that I am here on a special appearance as distinguished from a general appearance, and I am answering in the form of a demurrer. A demurrer is an old way of pleading. It's an old-fashioned, old-country, barrister English way of pleading without granting jurisdiction. In other words, I'll answer out of courtesy, and I'll give you an answer out of courtesy, but at no time am I granting jurisdiction. Now, I put on my briefs. I state my name, I state the defendant in propria persona, on a special appearance is distinguished from a general appearance for jurisdictional challenges. Now, I've raised the issue of jurisdictional challenges. I'm putting on the record. It's clearly cognizant. Once jurisdiction is raised, the burden is on the plaintiff to prove jurisdiction pursuant to McNutt v. General Motors Acceptance Corporation, recorded at 56 Supreme Court 502. It says, jurisdiction may never be assumed, but must be substantively proven by the plaintiff claimant. They don't prove it in a timely fashion, laches incurs. Laches is a species of action wherein a party of reasonable intelligence and integrity having a right to take an action as is prescribed by law, and having failed to timely do so, loses all right to proceed. So if they don't prove it timely, motion to dismiss, Your Honor, failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous case. Does that make sense to you? All right, now, let's get into this Erie Railroad case. This is a railroad case. What it's about, it's a guy was walking down the track and a board was hanging off the end of the train and whacked him upside the head. He tried to sue in the state courts. The state courts hammered him. So what happened was Erie Railroad had flipped around and they tried to sue him in the federal courts to get back at him. And they thought they were pulling a fast one. And what happened was the case bounced back on them. And guess what? When it bounced back, it created a very, very dangerous thing. Now, before this, I want you to understand that for 100 years of the law, this case was the one that was the leading case before this. And this was called McCulloch versus Maryland, the state of Maryland. This case is recorded at, it's an 1819 case. It is an old case. And it upheld for years the single citizenship relationship, and it deals with corporations. The power of establishing a corporation is not a distinct sovereign power or end of government, but only the means of carrying into effect other powers which are sovereign. Whenever it becomes an appropriate means of exercising any of the powers given by the Constitution to the government of the United Union, it may be exercised by that government. Now, basically, it sets up relationships. The Bank of the United States has constitutionally a right to establish its branches or other offices in discount and deposit within any state. All right? The state within which such branch may be established cannot, without violating the Constitution, tax that branch. All right? See these reporters in the early... This is 1819, folks. That's when this case came down. So this was going to be, you know, shortly after the Constitution was signed. 1791 is when the Constitution was signed, so it's going to be an early case. All right, William McCulloch, defendant, below in your branch. Normally they state the case one place and they state it But anyway, to make a long story short, McCulloch versus Maryland is a very heavy case. It was the law of the land, and it was replaced by Erie Railroad versus Tompkins. There is no federal, can you see that? There is no federal general common law. Congress has no power to declare substantive rules of common law applicable in a state, whether they be local in their nature or general, whether they be commercial law or in part of the law of torts. And no clause in the Constitution purports to confer such a power upon the federal courts, except in the matters governed by the federal Constitution or by acts of Congress. The law to be applied in any case is the law of the state. Got me? And whether the law of the state shall be declared by its legislature in a statute or by its highest court in a decision, not a matter of federal concern. Now, in disapproving the doctrine of the Swift versus Tyson, the court does not hold unconstitutional Section 34 of the Federal Judiciary Act of 1789 or any other act of Congress. Title 26. It merely declares that by applying the doctrine of that case, rights which are reserved by the Constitution to the several states have been invaded. That's why they can get away with having Title 26 without having no asterisk. They don't have to have it in law. They're claiming it's an act of Congress. And if you voluntarily enter into it, guess what? You bought the whole farm. A federal court exercising jurisdiction over such a case on the ground of diversity of citizenship. What am I talking about? Diversity of citizenship. I'm talking about dual citizenship. Right? Is not free to treat this question as one of so-called general law, but must apply the state law as declared by the highest state court. Swift versus Tennyson, overruled. The liability of the railroad company for the injury caused by negligent operation of its train to its pedestrian on a much-used beaten path on its right-of-way interstate, right, along and near the rails depends in the absence of a federal or state statute upon the unwritten law of the state where the accident occurred. Now what they're trying to do here is they're trying to justify the existence of this duality of citizenship between common law citizen, which you are, most of you, and this natural national citizen, which would fall under Title 26 United States Code. But I'm telling you to look up Section 6331A of Title 26, and you will see that the Secretary of Treasury has jurisdiction only over corporations, officers of corporations, and officers of government residing in the District of Columbia and artificial corporation, who are contractors of the fund. If you guys are going to be in this seriously battling and want to argue jurisdiction, which is a very good defense on almost anything they can pull on you, you're going to have to read these cases. Erie Railroad versus Tompkins, recorded at 304. That's volume 304, U.S. Page 64 is where it starts. It's vital that you understand these arguments. I just finished battling a United States attorney, and we were arguing, and he's talking about this is all gibberish. And I told him, I said, sir, I don't think you're well read on the law. All you got to do is read several of these cases, and they'll tell you, 1, there is a duality of citizenship. 2, it has to be clearly defined. And 3, I have defined it. And now I'm asking you to prove that I'm not a party. Or prove that I am a party. You tell me. It's your burden. You're the one making the complaint. You make the complaint, you get the burden of proof. Who says so? McNutt versus General Motors Acceptance Corporation, 56 Supreme Court, Section 5, or page 502. You made it, you prove it. Okay? You don't prove it timely, I motion to dismiss. Failure to state a cause of action for which relief can be granted. And also, we should tell you that if anybody violates your rights, okay, Title 42 United States Code, Section 1983. Everybody got this? Can you see it? Every person who, under color of statute, ordinance, or regulation, custom or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and the laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for the redress. For the purpose of this section, any act of Congress applicable exclusively to the District of Columbia. Why do you think they said that? Because they're members of the fund. And they are under Title 26, Section 6331A. Shall be considered to be a statute of the District of Columbia. Now, does everybody understand about admiralty and maritime jurisdiction? I know you don't, but not a little bit. They have created a duality of citizenship under the 14th Amendment. They're claiming there's common law rights, which everybody gets their Constitution, and there's national rights where you waive all your Constitution. Now, which did you want? Does that sound like a good deal? Sounds like you're being ripped to me. Here we got the 1-207. Remember, 1-207, right? Alright, now. Okay. Where are we at here? We want to show Jack McLam's magnificent books too. Vampire Killer 2000 and the Aid and Abet newsletter. We need to get these out to every police officer in the United States of America. They need to understand what the heck's going on here. You get a hold of Jack McLam and his people at Vampire Killer 2000 and they will be happy to put this book out. This explains to your police officers exactly what the heck's going on. And that'll be the close for today. Now, those of you who have been in militia groups and everybody's getting all panicky, let's understand a few things about the militia. Whether you like it or not, you are in the militia in the state of Michigan. And I will tell you right where it says that. Article 17, militia, right here. What does it say? And this is from the 1850 Constitution. All the way back in our state to the Northwest Territories treaty, they have a militia. But this is an example of what they're talking about. The militia shall be composed of all able-bodied male citizens between the ages of 18 and 45 years, except such as are exempted by laws of the United States and of the state, but all such citizens of any religious denomination whatever who from scruples of conscience, alright, in other words, if you're a conscientious objector, may be adverse to bearing arms, shall be excused therefrom upon such conditions as shall be prescribed by law. And they have conscientious objector statuses, okay? Then you go to the 1908 Constitution, just to show you that this is the God's truth here. 1908 Michigan Constitution. The Michigan militia shall be composed of all able-bodied male citizens between the ages of 18 and 45 years of age, except such as are exempted by laws of the United States or of this state, but all such citizens of any religious denomination who, from scruples of conscience, may be adverse to bearing arms, shall be excused therefrom upon such conditions as shall be prescribed by law. Okay? Now, that's the 1908 Constitution. Now you come up here. Now this just lets you know the trend. The trend here. Now, we're in the 1963 Constitution. And in the 1963 Constitution, common law and statutes in continuance in Michigan, the common law and the statute laws now in force, not repugnant to this Constitution, shall remain in force until they expire by their own limitations or are changed, amended, or repealed. So the common law is prevailing. The militia, here we go. I knew we had seen it. Now notice, folks, as the thing goes on, it gets shorter and shorter. Here's your militia. This is Article 3, Section 4. The militia shall be organized, equipped, and disciplined as provided by law. That's all you get now. Now, when you look in the beginning of this Constitution, there is a empowering statutory phrase that says, all constitutions before, everything they had in them are carried forward to this Constitution. And that's how they're allowed to do this. So, what would happen in this case, because they haven't clearly defined it here, they would have to go back in the law to the previous Constitution, which would be the 1908 Constitution, which we just read to you. Well, this one right here. So this one would be the militia shall be composed of all able-bodied male citizens 18 to 45 years of age. So that would be the controlling one, because that's as prescribed by law, just like they said. Does everybody see that? Now, the bottom line here, folks, is a lot of people are all upset about the militia. All the militia is concerned citizens that are worried about their Constitution getting flushed down a toilet. We're not putting up with that stuff. We want people to understand that we love the Constitution, we love our country, and we're not screwing around. Alright, here we go. Generally, the militia shall be organized, equipped, and disciplined as provided by law. Now let's get into that. The single section is substituted for all of this relating to the militia in the present 1908 Constitution. Remember I told you about empowering? The existing article ties the legislature down to an outmoded concept of what the militia should be. You believe that? Boy, our forefathers would be rolling over in their grave. Details as to organizing, equipment, and disciplining the militia are left to the legislative enactment in the interest of the flexibility and future requirements. Ah, does that mean future requirements, if it got nasty and down and dirty, we would have our militia come back? Sounds good to me. I could go for that. The bottom line is the people that know what's going around are not screwing around. They join the militia. Okay? But it is said that the laws of the Union are to be the supreme law of the land. What inference can be drawn from this? Or what would they amount to if they were not to be supreme? It is evident they would amount to nothing. A law, by the very meaning of the term, includes supremacy. It is the rule which those to whom it is prescribed are bound to observe. This results from every political association. If individuals enter into a state of society of laws of that society must be the supreme regulator of their conduct. If a number of political societies enter into a larger political society, the laws which the latter may enact pursuant to the powers entrusted to it by its constitution must necessarily be supreme over those societies and the individuals of whom they are composed of. It would otherwise be a mere treaty dependent on good faith of the parties, and not a government, which is only another word for a political power and supremacy. But it will not follow from this doctrine that acts of larger society, which are not pursuant to its constitutional powers, but which are invasions of the residuary authorizes of the smaller societies, will become the supreme law of the land. These will be merely acts of usurpation, which is kind of what's going on, and will deserve to be treated as such. Hence we perceive that the clause which declares the supremacy of the laws of the Union, like the one we have just before considered, only declares a truth which flows immediately and necessarily from the institution of the federal government. It will not, I presume, have escaped observation that it expressly confines the supremacy to laws made pursuant to the Constitution, which I mention merely as an instance of caution in the convention, since the limitation would have been to be understood though it had not been expressed. Though a law, therefore, for laying a tax for a use of the United States would be supreme in its nature, and could not legally be opposed or controlled, yet a law for abrogating and preventing the collection of a tax laid by the authority of the state, unless upon imports and exports, would not be the supreme law of the land, but an usurpation of power not granted by the Constitution, as far as an improper accumulation of taxes on the same object might tend to render the collection difficult or precarious. This would be a mutual inconvenience, not arising from the superiority or defect of the power. Now we want to get into some serious arguments here. We want to go to page 108. About the middle of the page. Except as to the rule of apportionment, the United States have indefinite discretion to make requisitions for men and money. That means they can ask. But they have no authority to raise either by regulations extending to the individual citizens of America. That's why we don't have a Title 26 that applies to you. The consequences of this is that, though in theory their resolution concerning those objects are laws constitutionally binding on the members of the Union, yet in practice they are mere recommendations which the states observe or disregard at their option. This is the intent of the framers. Cohen versus Virginia, 6/2/1821 says this is the exact intent. Is it pretty hard for you to understand what their intent was? They never intended to have an internal revenue. Ever. They hated people that operated like that operated a tyranny against the people. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in Constitution or laws of any state to the contrary is notwithstanding. The indiscreet zeal of the adversaries to the Constitution has betrayed them into an attack on this part of it, as also without which it would have been evidently and radically defective. To be fully sensible of this, we need only suppose for a moment that the supremacy of the state's constitution had been left complete with a saving clause in their favor. In the first place, as these constitutions invest the state legislature with absolute sovereignty in all cases not excepted but the existing Articles of Confederation, all the authorities contained in the proposed Constitution. Remember I told you about how they tied them together? So far as they exceed those enumerated in the Confederation, would have been annulled. See that? And the new Congress would have been reduced to the same impotent condition with their predecessors. Article 1, Section 9, Clause 4. No capitation or other direct tax shall be laid unless by the proportion to the census or enumeration as hereinbefore directed to be taken. Well, folks, they're not using the census. They're not using apportionment issue at all. They're evading it totally. Judge Beers filed in court the case of Evans v. Gore, recorded at 253 U.S. 245. Judge Evans sued I.R. Gore of the Internal Revenue Service because he claimed that the Internal Revenue Service diminished his salary during his continuance in office. And we all know that judges of the Supreme Court and Inferior Court shall hold their office during good behavior and shall receive for their services a valuable compensation which shall not be diminished during their continuance in office. That's Article 3, Paragraph 1. Wait, I'm sorry. Let's see. Article 3, Paragraph 1. The judicial power of the United States shall be vested in the Supreme Court and such inferior courts as may from time to time ordain and establish. The judges both of the Supreme Court and inferior court shall hold their office during good behavior and shall receive at stated times for their services a compensation which shall not be diminished during their continuance in office. Well, guess what, Your Honor? They diminished my salary during my continuance in office. You'll notice that there was no diminishment specified, so all diminishment is forbidden. Okay? And since all diminishment is forbidden, I am constitutionally immune from your income taxes. The Supreme Court came back and said, excellent argument. The 16th Amendment didn't create any new taxing power whatsoever, and clearly, Judge Evans is immune from income taxes, based on the Article 3, Paragraph 1, constitutional immunity. So up jumped the devil in the deep blue sea. Jimmy Carter was most unhappy, so he had to give the judges all a raise to shut him up. And he took his wrath out on Judge Beers, and he went and published the fact that Judge Beers was a bigamist, and he kind of trashed him and got him disbarred and thrown off the bench, which I didn't think was a very nice thing to do at all, because Judge Beers was a good judge. Now, how does this affect you? Basically, this case of Evans v. Gore makes two basic statements. One, the 16th Amendment didn't create any new taxing power, and two, there was, what? An acceptable, possible immunity to the income tax, right? Whoa, I said. Let's go back to Article 1, Section 9, Paragraph 4. No capitation or other direct tax shall be laid unless by the rule of apportionment as hereinbefore directed to be taken. Didn't I have a right to be free from a direct tax on my property? A direct tax is one where I actually come in your pocket and I tax it. I had a right to be free from a direct tax on my property unless by the rule of apportionment as hereinbefore directed to be taken in Article 1, Section 2, Clause 2. Does that mean I'm constitutionally immune? It sure does. But you have to tell them and demand that it's a direct tax. You got to say it's a direct tax on my property. Now what are they going to do? They're going to come around and tell you this isn't under Title 26, this is under Title 27. And that really you're a coal miner, or you're a miner of some kind, or you're a manufacturing handgun someplace. Well, you ask them, all right, let's see the Form 4456. They'll send you the Form 4456, and sure enough, they're going to have you down under some excise tax where they're charging you under BATF for having some fraudulent claim that you're involved in mining or something that requires an excise tax, and that for the privilege of doing business, you have to pay a fee because you're a corporation, an officer of a corporation, or you reside in the District of Columbia. Now let's ask you, That's Section 6331A of the Code. Look up Section 6331A. Those are the only guys that the Treasury Department can levy against. That's the only ones. Are you any of those? No. How could that be? You're not any of those, they can't levy against you. If they can't levy against you, there's no jurisdiction over you. Got me? Does that make clear? I mean, if they could levy against you, they'd have jurisdiction. Now, if they levy against you and you pay them, guess what? You just gave them jurisdiction. You sign their documents, you sign their W-4 form, you don't put down there, like I told you, UD 1-207 without prejudice, guess what? You're in. So, you think. Now, isn't that fraud? Doesn't fraud void the contract? You need to read, folks. We need to get you down here and we need to read. There's so many beautiful arguments in here, I mean, we can just hammer them. What is income? There is no income defined anywhere in the Code. Oh, Section 61A of the Code says income is wages. No, it doesn't. It says Section 61A of the Code says this is a list of sources from which income could be derived. Not necessarily is be, but could be. And it's compensation. Now, think about the word compensation. Look it up in Black's Law Dictionary. You're going to find out compensation, to make whole. Now, if you're out there and you painted your neighbor's barn, and he told you he'd give you $300 by Christmas, all right? You painted the barn, and Christmas came and he didn't pay you the $300. Wouldn't you have a loss on paper? You would, wouldn't you? And wouldn't you have a gain? He would, wouldn't he? Now, let's say he pays you the $300. What do you got? Do you have a loss? No. Does he have a gain? No. What happened? An equal exchange of property. What happened? You changed your time of life property in labor for his consideration. You have a 0-0 balance. You aren't ahead and he isn't behind. And you aren't behind and he isn't ahead. That is compensation. That's what it means. To make whole. Now, what happens if he doesn't pay you? Doesn't he have a gain? He would have a profit, wouldn't he? A realized profit or gain. He got you to work for him and he didn't pay you, right? And you would have a loss, right? Does that make sense to you? Now, the only way you would have income, by the way they define it, in Brushaber versus Union Pacific and some of these other cases, Pollock versus Farmers Loan and Trust, first you would have to have a realized gain from some source, right? Before the period under consideration happened. Now, did you get paid any more than you agreed to? You didn't, did you? You got paid $300. You agreed to $300, you got $300. If you got $301, you had a gain. And if you were a corporation, an officer of a corporation, and a person that resided in the District of Columbia was an officer of the government, you'd have a income. But you're not any of those. You're not a corporation. You're not an officer of a corporation. You don't reside in the District of Columbia as an officer of government. So you're, first of all, not even in the game. Second of all, you didn't receive anything above what you bargained for. Okay? So you don't have a realized profit or gain before the period under consideration was commenced, so you don't have any income. What you have is compensation. Before it can become income, it would have to be corporate property. You'd have to be a corporation, and you'd have to have a realized profit or gain. You don't have that. So don't tell anybody you have income. You ain't got none. Every time you volunteer to get in that, you get in trouble. Don't volunteer. Didn't they tell you that in the Army? Don't volunteer. You volunteer, you get the broom, and you get to drive it around the floor. Just ask me, I'll tell you. I know. Now, the bottom line is this. There's a lot of things that you need to know. The biggest thing is that you need to get a hold of one of these books, and you need to read it, cover to cover.